Tonight on It's the Law, last week, the U.S. Supreme Court was hesitant on making a judgment about drivers facing jail time for not wanting to take alcohol tests in the field. Several states have laws in place where if you refuse the test, you're headed to jail. Our legal analyst, Jay Davis, is here to talk more about that. So, Jay, is that a violation of your constitutional right, Fourth Amendment, saying that people don't have to, or people will go to jail if they don't want to take this breathalyzer test in the field?
Probably. Here's the problem. Generally, anything like that where you're going to be violated, you're going to have your privacy rights violated. So there has to be some probable cause. That's where the stipulation should lie. We've got a weird Supreme Court right now, so things are going to be very questionable.
Yeah.
It seems that the lower courts in these states have said it's permissible to require that and go to jail if you don't. However, they're taking away a right. The key is in driving, it's a privilege. So by driving, like in Georgia, we have an implied consent law, which means when you start driving, you've implied that you're going to consent to a search of bodily fluids and stuff like that. However, the police officers have to have some sort of probable cause. You can't just stop people to do it. You have to have some sort of probable cause to do it. And I think without the probable cause, they're not going to be able to do it.
So then, do you think that as law enforcement, that officers need warrants every time they pull over someone if they're suspicious of maybe driving intoxicated?
I actually think they need probable cause. I don't think they actually have to get a warrant from a court, but you have to be able to, what we call articulable. You have to be able to articulate, you have to be able to say exactly what was the reason you think this person might be intoxicated. So for example, in Georgia, if they see weaving, that may not, people weave for various reasons, drop something, moved, and that kind of stuff, but that is an indicator of alcohol use, and that's probably enough for probable cause in Georgia. So if they have the probable cause, they probably don't need the warrant. But I don't think that, as some of these states have done, they just make it mandatory to submit. If you don't submit, then that's a crime itself. I don't believe that that's going to hold up under the Fourth Amendment.
All right, Jay, thanks so much. And as always, we want to hear your legal questions. If you have them, email us at itsthelaw@41NBC.com. We'll do our best to answer it during our It's the Law segment each Wednesday on the news at 6.